can't hear myself. Let me know when you go live. Hello, hello, hello. I can't hear myself. Hello, hello, hello. Welcome to another beautiful Wednesday. Today is another Wednesday. Welcome to Dr. Olu Asekun podcast. Today we'll be discussing consular processing. Please call your friends, your family member, invite them to be part of this. This is a free opportunity to obtain information, and we do this every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That is 1 p.m. Eastern, and that is 10 a.m. Pacific. I can't hear myself. What? Am I not supposed to hear myself? I can't hear myself. Okay. So invite your family and friends so that you'll be part of this. Today, we are discussing consular processing. I honestly cannot hear myself. I ought to be able to hear myself. I ought to be able to hear myself. Okay, we'll come back to it later. Okay, we are discussing consular processing today. Consular processing. So what that means, there are basically multiple ways of obtaining legal permanent resident in the United States. For people who are physically present, applicants who are physically present, when they apply for permanent resident, it is called adjustment of status. Applicants who are outside the United States, when they want to apply for permanent resident or green card, they have to go through a process known as consular process. Consular process. And that is what we are discussing today. So peradventure, you have someone that you have filed a petition for, either employment-based or family-based, and that petition has been approved, but because the beneficiary is not present in the US, you have to go through this consular processing. Whether you are also the beneficiary of an approved petition, but because you are not physically present in the United States, you need to go through consular processing. And that is exactly what we are discussing today. So while I'm making the preliminary statement, you can continue to send in your questions. So if you have questions regarding consular processing, continue to send in your questions. You can send your questions to our WhatsApp numbers. I believe it's 817-883-4495. 817-883-4495. You can also send it to 817-983-4499. 817-983-4499. So send in your question so that by the time I finish the preliminary introduction, I'll be able to answer as many questions as possible. Time flies. In no time, it will be 1 hour. So start sending in your questions. Okay. Now, before a consular process can commence, there must be an approved petition. So approved petition can be in various forms. It could be I-130 petition, where the person filing, where the petitioner is a U.S. citizen petitioning for a family member, or a permanent resident petitioning for a family member. So there must have been I-130 approval before consular processing can commence. Similarly, if it is employment-based, there must be an approved I-140 immigrant petition for alien worker. So if it's an employment-based, there must be an approved I-140 immigrant petition for an alien worker. If it's a U.S. citizen trying to bring a fiancé, there must be an approved I-129F. There must be an approved I-129F. That is what a U.S. citizen, the petition that a U.S. citizen files on behalf of a fiancé. Whatever the case may be, whatever category, the issue is before consular processing can commence, there must be an approved petition. So once a petition is approved, then consular processing commences. Now, consular process is not automatic. It is not automatic. You can have an approved petition and consular process may never commence. So when the petition is filed, for consular process to commence, two things must happen. Either of two things must happen for a consular process to commence. It is either when the petition is being filed, the petitioner has indicated that the beneficiary is outside the country. So in which case, upon approval, because USCIS, that is immigration, because they already have advance notice that the beneficiary is outside the US, the petitioner is not required to take any additional step. Upon approval, USCIS themselves will forward the file, the approved file, to the National Visa Center. National Visa Center is where consular process commences. So, if the petitioner indicated right from the onset, before the petitioner was filed, if the petitioner indicated that the beneficiary is outside the country, upon approval, the USCIS will forward the file to National Visa Center, and that is where consular processing will begin. On the other hand, if the petitioner did not indicate that the beneficiary is outside the country, or in a situation where the beneficiary was present in the US at the time of filing, and of course, at the time of approval, maybe the beneficiary was now outside the US. In such a situation, the petitioner or the beneficiary will still have to apply to immigration by filing Form I-824 before the file could be forwarded to the National Visa Center. So, if you have an approved petition where it was not indicated initially that the beneficiary is outside the country, that petition may remain perpetual without being forwarded to the National Visa Center. So USCIS is not going to do it. They will just send you approval notice and the case will be static. Nothing will happen. So in order for such a case to be forwarded to the National Visa Center, the petitioner or the applicant must file a form known as Form I-824, Application for Action on an Approved Petition. Because without that application being filed, there will be no action on that case because you did not indicate at the beginning that the beneficiary was outside the country. So, very important to understand that. Now, start sending in your question as I go. Start sending in your questions so that as soon as I finish, we'll just go back to those questions. Remember to also invite your family, friends, so that you listen to this free advice. Also, remember to subscribe to our channel so that when we go live, you can be notified. Now, to commence a consular processing, as I stated, the process starts with the National Visa Center receiving the file from USCIS. So once the National Visa Center receives the file, they will contact the petitioner and provide an invoice and request the petitioner to create an account and then pay the immigrant visa fees. Now, the payment of immigrant visa fees depends on the type of application or the type of petition. In the case of employment-based petitions, affidavit of support is not required for employment-based petitions. So if it's a case of an employer bringing in an employee from overseas, no payment for affidavit of support is required because the law recognizes that this person is coming to work. So the question of becoming a liability or becoming a public charge does not arise. So there is no payment, there is no need for payment of affidavit of support. On the other hand, if the petition is a family-based petition, in addition to the immigrant visa fees, the petitioner will still have to pay for affidavit of support. The petitioner will still have to pay for affidavit of support. Now, upon the payment and the acknowledgement of all the fees, then the National Visa Center will open up the portal and allow the petitioner or the applicant to submit the immigrant visa application. So it is at this stage that the petitioner or the beneficiary will submit immigrant visa application. Along with that, they will also submit all the required documentation depending on the type of case. So the applicant may be required to submit biometric copy of the biometric page of his or her passport. The applicant may be required to submit birth certificate. The applicant may be required to submit police report from every country that he or she has lived for at least 6 months since age 16. So in other words, if the applicant, maybe 10 years ago, the applicant went to school in Germany or in England and was in school for 2 years, and now upon graduation, the applicant went back to his or her home country. When an immigrant visa application is being completed or submitted, the applicant will need police clearance certificate from his or her home country and will also need police clearance certificate from that country where he or she went to school because he or she lived in that country for at least 6 months. Every country that an applicant lived for at least 6 months since the age of 16, the applicant must obtain police clearance certificate from those countries. It is a mandatory requirement of the law. So once all the required documentations are submitted, then the National Visa Center will contact the U.S. Embassy in the beneficiary's home country or the country that was designated in the immigrant visa application. Now, for you to designate a country other than the beneficiary's home country, the beneficiary must have legal status in that country. For example, if the beneficiary is from Kenya and the beneficiary is currently living in England, for National Visa Center to forward the file to the U.S. Embassy in England, the beneficiary must show evidence that he or she is legal in England. He or she must have legal status in England. Otherwise, they will not forward it to the U.S. Embassy in England. They will rather forward it to the U.S. Embassy in his or her home country. This is because the American government cannot be part of illegality. So if an applicant or a beneficiary is living in a foreign country illegally, American government will not participate in that illegality by allowing the applicant or the beneficiary to attend U.S. Embassy interview in that foreign country. So the applicant or the beneficiary will have to go back to his or her home country in order to continue the processing. Now, the National Visa Center will contact the U.S. Embassy in the beneficiary's home country or in any other country where the beneficiary is currently living legally. Now, the embassy will provide available dates. It is not the embassy that will schedule the appointment, but it is the embassy that will provide available dates for the National Visa Center. It is the National Visa Center that will schedule the appointment. So once the National Visa Center issues appointment letter, it is at that stage that the applicant or the beneficiary will contact the U.S. Embassy in his or her home country or in the country where he or she lives legally. The U.S. Embassy in that country will now notify the applicant or the beneficiary of the places or a place to attend medical examination for the purpose of the interview. Everyone applying for permanent residence in the United States are obligated, are mandated to undergo medical examination. Whether you are applying physically here in the US or you are applying from outside the US, everyone applying for permanent residence are required to obtain medical examination. So it is at this stage that the embassy will provide information to the applicant of where to go for the medical examination. Whether you are inside the US or you are outside the US, it is the government, US government, that determines which clinic or which hospital will perform medical examination. So it is not the petitioner or the beneficiary. So you don't just go to your primary doctor and go and conduct medical examination and then provide the information. That is not the way it works. Whether you are here in the US physically, you have to go through approved medical clinics. If you are outside the US, you have to go through approved medical clinics approved by the US Embassy. So that is why it is mandatory that upon the scheduling of the appointment, the applicant must contact the US Embassy to find out where to conduct the medical examination. Thereafter, of course, the result of the medical examination will be sent directly to the US Embassy. Here in the US, if the applicant is physically present, the result will be provided to the applicant in a sealed envelope. The moment that envelope is open, that medical examination is no longer valid. The applicant will have to redo it again. So it will be provided to the applicant in a sealed envelope. Of course, the applicant is entitled to a copy of whatever is put in a sealed envelope. Also, when medical examinations are conducted internationally outside the US, the applicant is still entitled to a copy of his or her medical record or the result of the medical examination. But the original result will be sent directly to the US Embassy in the applicant's home country. Now, after that, the applicant will now appear for interview on the date scheduled by the National Visa Center. So upon interview, if everything goes well, the applicant again will now be issued an immigrant visa. So depending on the category and depending on the circumstances, immigrant visas are usually valid for between 90 days and 180 days. So there have been cases where the applicant will have only 90 days, that is 3 months, to use the immigrant visa. And there are cases where the applicant will have up to 180 days, 6 months, to use the immigrant visa. So if the applicant does not use it within this period, the applicant will have to start the process all over again. Now, upon the issuance of the immigrant visa, that is still not the end of the process. The applicant is still required to pay green card processing fee here in the United States. The applicant, or through his or her petitioner, is still required to pay a green card processing fee here in the United States and then provide an address where the green card will be mailed to. So the applicant, as I said, has between 90 days and 180 days to use the immigrant visa. So upon entry into the United States, the applicant becomes a legal permanent resident on the day of entry into the United States. So by now, there should be questions. So keep the questions coming in. I think I will need help. I can't see the question. Keep the questions coming in. Keep the questions coming in. Keep the questions coming in. Thank you. Oh, we already have lots of questions. Okay, that's a good thing. First question: does the petitioner need to be present at the interview abroad? No, petitioners are not required to be present. In fact, in most cases, the petitioner will not even be allowed to enter the interview place, the embassy, for the purpose of the interview. Petitioners are not required. However, in some exceptional situations, especially where the embassy have reasons, if it's a spousal relation, if it is spousal petition, and if the embassy have reasons to doubt the relationship, if the petitioner appears at the interview, the petitioner may be allowed to enter the interview place in order for the petitioner to answer questions relating to the relationship. But other than that, that is even at the discretion of the consular officer. So, but generally, petitioners are not required to be present, and even where they are present, they may not be allowed to be part of the interview. Next question. I heard that I won't get my immigrant visa approved unless I get vaccinated against COVID. How true is this? Yes, this is true. It doesn't matter whether you are in the US or you are outside the US. The law requires everyone applying for green card to show evidence of vaccination, even though there are very, very limited exceptions. Limited exception in that if you have a legitimate reason why you cannot take the vaccine, the consulate may consider it, or USCIS, in the case of those who are physically present, they may consider it. But since COVID broke out in 2020, I can tell you personally in this office, we have not seen a case that was waived. We have seen cases of people who requested a waiver that they don't want to take the vaccine. But of course, we have not seen any of those cases approved. So I'm not saying that the waiver is not available, but again, I've not seen anybody approved. So yes, it is mandatory that you take the vaccine if you want to apply for green card here. The next question: if an alien is in the US, may he apply for both consular processing and adjustment of status at the same time? No, you cannot do both at the same time. You have to do one, either or. You can't be applying for adjustment and at the same time processing conducting consular process. No, it doesn't work that way. You have to do one. So if the applicant is physically present in the US and the category upon which he or she is applying, he meets the requirement, because adjustment of status also have a lot of requirements. It's not only the approved petition. For example, in order to adjust, you have to show evidence of legal entry. You have to show evidence that you entered the United States legally. So because even if you are married to a US citizen, if you walk in through the border, if you don't have a valid visa, if you enter illegally, you may still not be able to adjust your status. So it is not automatic that because you have an approved petition, you are just going to get approved. No, that is not the way it works. So in order to be able to adjust, you must show evidence of legal entry. So the applicant cannot pursue adjustment as well as consular processing. No, because for consular processing, the file will have to be forwarded by immigration to National Visa Center. Immigration and National Visa Center are not part of the same department. Immigration, USCIS, is part of the Department of Homeland Security. National Visa Center is not part of the Department of Homeland Security. They are part of the Department of State. They are part of the Department of State. So you can't have your file in two departments at the same time. So if you are here and you want to apply for adjustment, Department of Homeland Security will handle your case. If you are outside the country and you want to apply for consular processing, the Department of State process your case. So you can't do both. However, let me clarify this. However, if you apply for adjustment and your adjustment is denied, maybe on the basis that you didn't enter legally or some other basis, in some limited situation, we can actually withdraw. If this will have to be before approval or even after a denial or even after denial. In some limited cases, we can actually request Department of Homeland Security to forward the approved petition to National Visa Center so that the beneficiary or the applicant will go back to his or her home country in order to go and apply for consular processing. That is assuming that there are no other issues of grounds of inadmissibility. Next question. May an alien who chooses to apply for consular processing take advantage of work permit and or advance parole while their petition is processing? No, that is not even possible. There is no avenue to apply for work permit if you are doing consular processing. Remember, anybody who is doing consular processing, they are outside the US. They are not in the US. Work permit and advance parole are for people who are physically here. They are already here. So they are telling immigration, allow me to start working before my green card is approved. Allow me to start working while my application is pending. Allow me to be able to travel abroad temporarily while my application is pending. That is what work permit and advance parole is all about. So if somebody is already outside, he or she is not eligible for work permit. There is no provision for that. So work permit can only be approved by the Department of Homeland Security. And like I said, consular processing only involve processing by the Department of State. Next question. My petition I-130 was approved 5 months ago. The approval notice states that my file has been forwarded to the National Visa Center, but we have not been contacted. What can I do? If your file has been forwarded to National Visa Center for more than 5 months, the first thing you need to check is whether your information is correct, because I can assure you that the National Visa Center will have made attempt to contact you either by physical mail or by email or by both. So the first thing you need to find out is the email you provided in your application or in the petition, is it a valid email address or was it erroneous? Because if you misspell the email or you provided an incorrect email, they may not be able to contact you. The second thing is the address you have on file when the petition was filed. Are you still living in that address? Is the petitioner still living in that address? If the petitioner has moved and no change of address has been provided, the National Visa Center may have sent a mail to that address, and that mail may have been returned. So that is the first step. Go and verify that your information is accurate. Because one of the dangers of consular processing, unlike adjustment, is that the National Visa Center will terminate the proceedings if you fail to contact them within 1 year after they last communicated with you. If the National Visa Center sent you a letter or any form of contact today, if you don't contact them within the next 1 year, by August of next year, that case will be terminated and they will shred the file, they will shred everything. So you don't want to be in a position where your case is terminated. So you have to find a way to contact the National Visa Center. So if you check your address and you realize you have moved, you have not done a change of address, the first thing will be to call the National Visa Center and notify them of a change of address. And of course, when you make that call, make sure you have a copy of the approval letter so that you will be able to give them the receipt notice that was issued by USCIS, because the assumption is that you may not have the NVC number at that stage since you have not received any communication with them. But if you call them and provide them with USCIS receipt number, they may still use that to locate your file and then update your address. But if you have a lawyer, your lawyer should be able to do all this without any problem. Next question. What are the benefits of applying for consular processing? There is no benefit or disadvantage. It's just a matter of your location. It's a matter of where you are, and a matter of location and matter of eligibility. So if you are in the US and you are eligible for adjustment of status, then you apply for adjustment. But if you are not in the US, you are outside the US, and you apply for consular processing, that will be the only thing you are eligible for. However, there may be situations where somebody is eligible for both. For example, maybe you have a valid visiting visa and you come in to the US and go out from time to time. Now you have an approved petition. So you are trying to determine, do I apply for adjustment or do I follow consular processing? Well, that would depend on your personal situation. For example, if you are the busy type that cannot afford to stay out of your country for months, then consular processing may be your option, because the moment you apply for adjustment, it invalidates your visiting visa. You will no longer be able to go out of the US and come back until after either the green card is approved or advanced parole is approved for you. So once you know that you do not have that kind of time, if you cannot stay in the US for months, maybe 6 months to 1 year, then if you are the type that you come in, spend about 2-3 weeks and you have to leave, then consular processing may be your best bet, because that will not force you or require you to stay here for months. The next question. An alien's national interest waiver petition is approved, but their H-1B is going to expire. Can they apply for either consular processing or adjustment of status? Well, since this person mentioned H-1B and also national interest waiver, so this clearly shows that we are talking about employment-based here. So the first thing to find out before you even determine whether you can apply for either of them, the first thing is to find out if visa is available in that category. Because right now, depending on the priority date, but right now, national interest waiver category is not available. Visa is not current in that category. But again, it depends on the priority date. So this is a general question. So I'm giving a general answer. So I don't know the specific priority date. So depending on the priority date. Now, if you are on H-1B, it means that this person is working in the US because H-1B is a temporary work permit. You are allowed to work for an employer in the US on a temporary basis. Now, if this process requires the filing of a labor certification, if your labor certification application has been pending for more than 1 year, your H-1B could be extended beyond the 6 months, the 6 year limit. H-1B could be extended beyond the 6 year limit if you have a labor certification that has been pending for more than 1 year. Or if you, well, that is the only situation that is applicable in this case because apparently this person has not filed the adjustment application. So, but if it is a process that does not require labor certification, as in the case of a national interest waiver, then you cannot even extend the H-1B on that ground. At the same time, you cannot apply for adjustment of status or consular processing until visa becomes available. So if this person is in the US, you will have to find other means to keep yourself in status because one of the fundamental challenges with employment-based visa is that an applicant must maintain legal status at all times pending the submission of application for adjustment of status. An applicant in an employment-based petition must be in legal status at all times pending the submission of adjustment application. Next question. I became a US citizen after the petition for my children were approved. Should I update the National Visa Center? Will this help to expedite the cases? Well, whether it will help or not, if your status has changed from a permanent resident to a US citizen, you are mandated by law to update the National Visa Center. So it is not a matter of whether it will help or it will not help you. Because if you are a US citizen and you did not notify them, that will be committing fraud. And if they find out later, it may have an impact on your case. So whether it will help you or not, once your status change from a permanent resident to a US citizen, you have an obligation to notify the National Visa Center and provide them a copy of your certificate of naturalization. That is the first thing. Now, whether it will help your case or not depends on a number of factors. Like I said, this is a general question. I don't know how old these children are because for immigration purpose, you have to look at the definition of family. Family of a US citizen is different from family of a permanent resident for immigration purpose. For example, a permanent resident, the family include only the spouse and minor children. Only the spouse and minor children. Even the spouse, if the spouse is present in the US, in order to apply for adjustment of status, the spouse must be maintaining legal status at all times. So it is not the same with US citizen. For US citizen, family of a US citizen include the spouses, include children under 21, and it include parents. It includes parents. It also includes fiancé. So all these, the beneficiary, a green card holder does not have that benefit. That is why a green card holder cannot petition for a fiancé. That is why a green card holder cannot petition for parents. Only US citizens can do that. That is why a green card holder cannot petition for siblings. Only a US citizen can do that. So if these children are minor, if they are under 21, yes, notifying them that you are a US citizen will definitely have an impact on the application because it becomes a immediate family member of a US citizen. Next question. I have been told that I need to provide my social media handles on the DS260, even if I'm no longer using them. Why is that? Well, that is to enable them conduct a thorough background check on you. Everyone applying for permanent resident here in the US, everyone applying for permanent resident here in the US must undergo background screening. They don't want to give permanent resident to terrorists. They don't want to give permanent resident to fraudsters. They don't want to give permanent resident to criminals. They don't want to give permanent resident to some people that they believe will come in here and start creating problems. So everyone applying for permanent resident has to undergo background screening. So in this day of social media is also part of the screening. So if you want to live here, they want to know who you are. So they want to know what you have done, what you have posted in the past. Maybe you have posted threatening messages that you want to kill somebody. Maybe you have done some. They just want to know who you are. So it is part of the screening process. It is for the same reason that people have to provide fingerprinting. What do they do with your fingerprinting? They use it to check your background. So nowadays, they also use social media to also check your background. So it is part of the screening process. The next question. As you may already know, the situation in Sudan is horrible. My case is pending in Sudan. Can I request for a change of country for my case to be processed? Yes, you can request for a change of country. Yes. In actual fact, in this office, we have done that on behalf of clients. Since the war broke out in Sudan, we have had to transfer some of our client cases from Sudan to Egypt, and they have been transferred. Yes, you can do that. You can do that. But before I go to the next question, you must be legal in the country where you want them to transfer it to. So as I explained earlier, American government will not be part of illegality. So if you want them to transfer it to a different country, you must be legal in that country. You cannot go to that country illegally and then expect them to transfer it to that place. Yes, that is part of being legal. You have to provide proof of address in that country. Yeah, you have to show that you are legal in that country. So it's not just enough to just say, oh, transfer it to Egypt or transfer it to Algeria. You must show that you have proof of legal status in that country. Next question. Can the petitioner be living with me in my country while the NVC processes my case? Yes, petitioner can live wherever he or she wants. However, let me say this. Because you are coming to live in the US, if this is a family-based petition, remember, the petitioner has to submit affidavit of support. The petitioner has to show that you will not become a liability here. So if the petitioner himself or herself, as the case may be, does not have income here, living with you in your home country may create doubt as to the petitioner's ability to support you. In actual fact, from experience, some years back, I remember in this office, we represented a client where the petitioner moving to Africa to live with the beneficiary. But eventually, when the beneficiary appeared at the interview, I believe that they checked the petitioner's background and realized that she has been out of the country for almost a year or more. Remember, the petitioner is going to travel with American passport. American passports are issued by the Department of State. So the embassy is part of the Department of State. So they can know your travel history without you even telling them. They can know all these things. So they knew that the petitioner has been out of the country for a long time. So they now told the beneficiary, remember, the petitioner was not allowed to be part of the interview, but they told the beneficiary to go and submit a picture of the petitioner standing in front of the post office in the US. So they know some of these things. So it may be risky, except if it is just to spend some time with you and go back. So it may be risky if the petitioner lives with you in your home country for an extended period of time. So it may be risky. So you don't want to do that except the petitioner is self-employed and living in your home country will not affect his or her source of income. Next question. My father petitioned for me. I now have 2 children, and MVC is ready to process my case. Can I include my children? Also, can I now get married to my children's father? This is a very, very, very technical question, and very interesting, because this is one of those things that get people into trouble. This is one of those things that create a lot of problem for people. Number one, if your parent is the one that petitioned for you, and that petition was filed as unmarried child of a US citizen, the moment you get married to your spouse, to the father of your children, you will no longer qualify for that category. So you need to understand that. That is the first mistake. The moment you get married to that person, before entering the US, before getting your green card, you will no longer qualify for that category. So the second question, can you include your children? Yes, if they are minor, you can include them only if they are minor. If they are under 21, yes. But if they are 21 and older, you can no longer include them. Next question. I was told the clinic needs to run further tests to get the medical exam ready, but it will take 10 more weeks to get the result, which is after my interview date. What can I do? There is really nothing you can do other than to wait, because I don't know what they found out in your test that require additional tests. So you can't do anything other than to wait. You have to wait for them. It's a mandatory requirement for anybody applying for green card to not be disqualified on grounds of health or on medical grounds. So that there are several grounds of inadmissibility, which it may include criminal grounds, it may include prior immigration violations, it may include health grounds. So you have to wait until they find out what the issue is with the test. However, the fact that one of the tests came out positive or negative is not by itself a ground, or is not by itself an assurance that you are going to be denied. It depends on what is found, and it depends on whether it is something that can be waived or whether it is something that you only merely need to provide insurance and all. So it depends on a number of factors. But for now, there is nothing you can do until that test is conducted and completed. That is the only thing you can do. You have to wait. Yeah. You still have to attend the interview anyway. You still have to attend the interview. But you can't do anything, but you still have to attend the interview. Next question. I am outside of the country and my spouse is a permanent resident right now, but she is about to be a citizen. Is it better to petition now or wait until she's a citizen? You can go ahead and petition because, as I explained earlier, a permanent resident, the spouses of permanent resident includes immediate family. Spouses of U.S. citizen also include immediate family. And many of these things nowadays, especially since COVID, many of these things takes time. So when the petition is submitted, the day that the petition is received by immigration, that day is known as priority date. So it is better for you to submit the application now so that you maintain your priority date. So when your spouse eventually becomes a U.S. citizen, all you need to do is just to update them. If your petition is still with the USCIS, you just update them that your spouse is now a U.S. citizen. If your petition has moved to the level of a National Visa Center, you just update them that your spouse is now a U.S. citizen. So the earlier you start, the better. You don't have to wait until your spouse becomes a U.S. citizen because you are outside the U.S. If you are inside the U.S., it may be a different ball game because if you are inside the U.S. and you are not in legal status, a permanent resident spouse may not be able to give you the benefit of adjustment. So it is better to, but even if you are inside the U.S., you may not be able to apply for adjustment, but you can still submit the petition itself and then wait until your spouse becomes a U.S. citizen before you can now submit adjustment application. The next question. What are the fees involved with consular processing? Well, the fee is case specific. It's not something that is a one cap fits all. It is case specific. So it depends on the family size. It depends on the type of application or petition. It depends on whether it is employment based or family based. As I stated at the beginning of this podcast, for employment based, applicants are not required to pay affidavit of support fees. But for family based, applicants are required to pay affidavit of support fees. But I believe that generally for immigrant visa application, the fee is $325 per person. That is when you get to the stage of consular processing after approval. This has nothing to do with USCIS. We are discussing consular processing now. So it's $325 each. If your case require the payment of affidavit of support fee, that is one additional $120. That is additional $120. But if you are a large family and you are processing it at the same time, the affidavit of support fee may be paid once. But if you are processing it separately and independently, each person will have to pay affidavit of support fee whenever they are processing their own. Next question. Please continue to send in your question. We are very limited time now, but any question that I receive before 1 p.m. Dallas time, I will still answer, even if it is after this program is over. If I receive any question before 1 p.m., I will surely answer it before we close today. Okay. Next question. My child was below 21 at the time of the petition. He is now older than 21. Can he still get an immigrant visa? Well, this depends on a number of factors. And number one, it depends on who the petitioner is. Is the petitioner a U.S. citizen or is the petitioner a permanent resident? Number two, what category are we looking at here? Are we looking at immediate family or are we looking at extended family? So if we are looking at immediate family, if the petition was filed before your child turned 21, your child will still be covered because there is something called Child Status Protection Act. So if the petition was filed while your child was still under 21, your child is covered and is protected, assuming you are a U.S. citizen. It may not be the same if you are not a U.S. citizen, because if you are not a U.S. citizen, we have to determine whether visa was current at the time that you filed or visa was current before your child turns 21. And then there are some other requirements that you have to show in order to be eligible. What I will advise, because we don't have a whole lot of time, on this podcast, whoever sent this question, you go back to our YouTube channel and look at the podcast on Child Status Protection Act. We did a program on Child Status Protection Act. So go back to our YouTube channel, search the topic Child Status Protection Act. So we explain it thoroughly there. So if you meet the requirement of Child Status Protection Act, your child can still be covered. But even if you do not meet that requirement, if you are a U.S. citizen and your child does not require to go through the visa bulletin, your child will still be covered under Child Status Protection Act. The next question. My case is at the National Visa Center, and I have been waiting for a very long time for my interview. Can I expedite my interview date? Well, generally, I will tell you no. Even though the National Visa Center creates the impression that for some exceptional cases, one can request expedited processing. But the practical reality is that expedited processings are not available for immigrant visa processing, consular processing. Expedited processing are not available. As I explained earlier, the National Visa Center do not control the date with the embassy. So even if you are eligible for expedited processing, National Visa Center cannot grant that request. So the only one that can grant the expedited request is the U.S. Embassy. But again, because the U.S. Embassy is not the one that will give you an appointment, technically, they will not be able to give you expedited processing. So this is one very painful aspect of immigration law, because now National Visa Center will tell you, sorry, we can't do it because we don't have control over the embassy. It is the embassy that can give you expedited date. It is the embassy that can attend to you. Send your expedited request to the U.S. Embassy. Now, when you send it to the U.S. Embassy will tell you, sorry, it is the National Visa Center that will give you appointment. We cannot give you appointment, and because we cannot give you appointment, sorry, we are not able to expedite it. So this is a case of they will be playing you like ball. Because of the way that process is structured, it is the National Visa Center that will give you an appointment letter, but it is the U.S. Embassy that will provide available dates to the National Visa Center. So that except they modify that process, getting expedited process will be a Herculean task. We have attempted it several times for several clients. Like I said, when you apply to National Visa Center, they will tell you, sorry, it is the embassy that you should send your application to. When you send it to the embassy, you get the same thing. Sorry, because we are not the one to schedule the appointment, we cannot expedite it. So it's a catch-22 situation. So that is the unfortunate reality in that regard. Well, as I promised that if there are questions, received before 1 o'clock, I will answer it. For now, it is 1 o'clock, and I believe that the last question is what I've answered. Thank you again for joining us for this beautiful Wednesday. Always remember to join us every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. And that is 1 p.m. Eastern Time. That is 10 a.m. Pacific Time. And that is 6 p.m. Nigerian Time. At this time, it may become a different, the calculation may be different in Nigeria in the future when there is a time change. But for now, it is 6 p.m. Nigerian Time, 12 p.m. Dallas Time, 1 p.m. Eastern Time, 10 a.m. Pacific Time. Thank you again. Remember to subscribe to our channel. Remember to join us, invite your family and friend, and God bless you. Take care. Bye. See you next week. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. and we all celebrated. That's a good thing.
Another interesting thing about
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Lawyer Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he's the best lawyer. So far, so good.
our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury.